Welcome to the New York Business Leaders Podcast, presented by the Coyle Group. We interview the most interesting and influential business leaders in New York and hear their stories of success, challenges, and lessons learned while building their businesses and personal brands. New episodes drop weekly, so please be sure to subscribe to get updates in your favorite stream. Without further delay, here's your host of the New York Business Leaders Podcast, Gordon Coyle.
Welcome back to the New York Business Leaders Podcast. I'm your host, Gordon Coyle. On today's show, I welcome Yuval Marcus and Jordan Garner from the law firm Leeson Ellis to talk about intellectual property due diligence in mergers and acquisitions. Leeson Ellis is a law firm located in White Plains, New York that focuses exclusively on intellectual property matters. As you'll hear in a moment, intellectual property revolves around patent, trademarks, and copyrights. So with respect to mergers and acquisitions diligence, there's a lot of issues to talk about relative to ownership rights, potential threats to IP, and more. Pretty interesting conversation. In fact, many of the attorneys at Leeson Ellis have backgrounds and advanced degrees in biology, chemistry, engineering, computer science, genetics, physics, and more, in addition to their law degrees. So they've got a pretty deep bench of experts to help clients with IP issues. If you'd like to get in touch with Yuval or Jordan, you can go to leesonellis.com, which is LeasonEllis.com, and go to the professionals tab and search for their names, and you'll find their V cards, phone numbers, and emails there. Finally, if you have an interesting story that you'd like to tell on this podcast, why not reach out to me, Gordon Coyle? My direct dial is 845-474-2924, or you can email me at gbcoyle@thecoilegroup.com. I'll have my info and Yuval and Jordan's as well in the show notes, so if you can't get to it right now, you can pick it up later. Thanks. Now on to the show. Hey everyone, welcome back to the New York Business Leaders Podcast. I'm Gordon Coyle, and today I'm joined by Yuval Marcus and Jordan Garner from the Leeson Ellis law firm, which focuses on IP. In today's conversation, we're going to talk about intellectual property in mergers and acquisitions, diligence around IP, and all that sort of stuff. So I'm going to ask Yuval, do you want to spend just a couple of minutes telling us about yourself and what you do, and then we'll ask Jordan to do the same thing.
Sure. Thanks, Gordon. Thank you for having us on this program. We're very excited to talk about IP due diligence. Jordan and I form a team at our firm, Leeson Ellis, that does a lot of that work. We're doing primarily buy-side IP due diligence, and we'll talk about that a little bit later. My background is as a litigator, and one of the things that I bring to the table in terms of IP due diligence is helping evaluate litigation risk. I have been litigating IP disputes in federal courts throughout the United States for over 25 years now. And my experience runs from patent cases to trademark, trade dress, copyright, false advertising. And I'm the co-chair of the litigation group at Leeson Ellis. Leeson Ellis is a intellectual property only law firm. We have about 32 lawyers. And all we do is intellectual property. We handle everything that relates to intellectual property, and we do nothing else. So that's a little bit of background. We are based in White Plains, New York. Most of us have come from law firms, either large general practice law firms or other intellectual property boutiques in Manhattan. And that, I guess that's enough about me. Let's go on to Jordan.
Sure.
Thanks, Gordon. My name is Jordan Garner. I'm an intellectual property attorney along with Yuval at Leeson Ellis. My background is that I'm a registered patent attorney. My technical background, and for those who don't know, in order to be a registered patent attorney, you have to have a technical background. Mine was in biology and bioinformatics, or computational biology as it was. Yuval and I tend to work on these buy-side diligence deals where there is a significant component of either sort of a technology or medical device or pharmaceutical aspect, but really all sort of forms of IP diligence are things that we have experience handling. In terms of the size of the deals that we generally work on. We sort of do small deals up to billion-dollar transactions where we're brought in to look at the IP and assess the risk. Yuval tends to look at the infringement risk or the litigation risk that comes from these diligence transactions. I look at the patent or IP risk in terms of whether or not a company has sufficient IP to protect their product, or if they're going to get themselves into a problem because their competitors have patents that might cover their products. And so we form a good team that sort of goes through, analyzes these risks, and then provides our clients with options going forward with the transaction.
Great. So maybe let's just define a couple of terms for the layman out there that may not really understand IP. It's intellectual property, but do you want to give us kind of like the layman's terms of what IP is and what risks present themselves with IP, especially with regard to M&A? And then the next thing that I'm going to ask you to define is what is diligence? So, I'm sure a lot of people that aren't in the M&A field, which in of itself is mergers and acquisitions, don't understand what diligence is. So do you guys want to kind of just talk about what those two topics are for a second?
Sure. Let me start off. I'll just define trademarks and copyrights, and I'll let Jordan, since he's the patent lawyer, talk about patents and go from there. But intellectual property includes different types of rights. There are different things that you can protect. By its term, intellectual property are not tangible, as opposed to real estate or a building, which is an asset where you can touch. Intellectual property tends to be things that are less tangible, though they can be things that you can touch. But trademarks, in a shortcut for trademarks, really is brands. What a trademark does is it protects. If you've developed something that acts as a source identifier, and that can be anything. It doesn't necessarily have to be a name. It can be a color. It can be a smell. Anything that acts as a source identifier for goods or services can be a trademark. I mean, some of the, obviously most people think of it in terms of the names or logos. That those are the most traditional trademarks. In the context of diligence, we've had this situation come up. Sometimes what will happen is if a company, a larger company, is buying a smaller company, and there's a brand associated with the target company, and they want to expand that brand across the United States. That company may have trademark rights in a particular geographic area, but not necessarily throughout the United States. And so diligence, which we'll define in a moment, can involve figuring out whether or not, if the target company, is the brand of the target company amenable to be expanded, or if you expand it to other states, would you have a problem? So that's one of the kinds of things that we might deal with in a trademark context in a diligence situation. And copyrights are they protect creative expression, and so copyrights are things that include music, include literature, include movies. So anything that has creative expression that's fixed in a tangible medium can be protected by copyright. Photographs is a big topic now in the context of there's a lot of litigation where basically you post things on the internet and you don't necessarily have the rights to the copyright to that image, and you can get, a lot of people are getting sued for that. So that's another area where you have to just make sure that things are buttoned up, that people aren't using images on their website or in their promotional materials that potentially is owned by somebody else. And with that, I'll let Jordan define patents.
Okay.
Yeah. So patents, and maybe your viewers are slightly more familiar with them if they watch shows like Shark Tank, where the sharks are always asking about patents and whether or not companies have them. So what patents cover, patents are a grant by the government, either the U.S. government or a foreign body, that covers an invention. And inventions are sort of broadly described as things made by man, right? An invention might be a new chemical process, or it might be the new chemical compound itself. It might be a new pharmaceutical, or it might be a medical device. It might be a piece of software, or it might be, an invention that's a new machine of doing something. The way that you get patents is that you submit an application to the patent office, and then you and the patent office sort of negotiate as to whether or not you get to exclude other people from making, using, or selling your invention. And so once you've secured patent rights, you can exclude competitors making knockoff copies. You can sometimes exclude competitors from even making similar sorts of technology. The way this comes up, I think, probably for most people, is the difference between branded drugs and generic drugs. So branded drugs are usually drugs that still have a patent covering them. And so the competitors are unable to make that same drug. But once the drug goes off patent, as they say, then you get lots of generic competitors and the price goes down. So the function of a patent is usually to defend yourself against a competitive threat. You can get a patent in the US, it's sort of jurisdiction wide. So you get one patent and it covers all of the US, but it won't cover anywhere else. So you are able to file multiple patents in multiple countries on the same invention, and try to protect your sort of business wherever you might find sales. Similarly, the risk profile for patents is if you are starting to come into a market and you want to make a new product or service, there might be a competitor out there that has patents on those. And that's going to be something that in our diligence we look at and assess how much of a danger that might be to the company going forward.
Great. So, and you just touched on this, Jordan, is the diligence piece of it. So I'll let you guys describe what diligence is and kind of remind the viewers and listeners that we're talking about from a buyer's perspective. A company is buying a firm and they need to engage a panel of diligence experts around different risk factors to understand what they're buying, what risks they may be buying into, and how they may have to hedge those risks down the road. So do you want to maybe take that a little bit further?
Jordan, why don't you take that?
Sure. So, all types of diligences are, and we specifically tailor them to the needs of the client. But there are a couple of sort of common facets or factors that go into diligence, and mostly because we're on the buy side, our clients are coming to us. They have an interest in purchasing an ongoing concern, a company, a startup, even a well-established, NASDAQ listed company. And what they're asking from us is two things. One, on the sort of offensive side, does the company have protection for its branding, for its technology, for its sort of secrets? It's underlying intangible items that make that business worth investing in or worth purchasing. And so diligence from that standpoint looks at whether or not the company has patents, whether, as you've all said, the company has protected its branding, whether or not it's using photographs in a way that it shouldn't be using, or whether or not it's secured rights to that. On the sort of alternative side of that is the risk profile diligence, which is and these can be sort of in the same diligence process, right? So we can both look at the assets the company has and match them up with their technology. So if a company says, oh, we've got this great technology, we've got improved batteries, we're going to make a new electric vehicle, we can look at their patents and assess whether or not those patents are actually meeting what their sort of marketing statements are saying or what they're sort of pitching to the purchaser. Alternatively, we also look at the risk profile. So if a company says, we're going to deploy this new technology, we're going to come out with this new pharmaceutical, we can then go in and look at the patents in the United States or even in foreign countries and say, is launching that new product, is entering that new business going to incur litigation risk? Is there competition risk? Are a lot of people doing it? Is the field crowded? So really, diligence is sort of both assessing what the target company has in terms of defensible or assertable intellectual property, and also looking at whether or not the target is either already in a state where it might be getting into trouble with infringing others' intellectual property, or if they're going to get into a situation where a little ways down the road, a year or two, it seems like they're going to run into problems.
Got it. Yuval, anything to add there? I think you covered it pretty well.
Yeah, no, I just want to say that there's sort of different levels of diligence. Like at the most basic level, diligence covers sort of making sure that the target company owns what it says it owns, and just running down, because a lot of times Patents typically will get filed the name of an inventor, and then they get assigned to a company. So one of the things that you need to do is just make sure that those assignment documents were actually signed and properly filed, and that the company actually owns, the patents that they claim that they own. We often find that, a lot of times, a company has gone through various iterations or have had predecessors, and sometimes they haven't buttoned up just to make sure that the company is the actual owner of what it thinks it owns or what it claims to owns. And one of the things we can talk about later is the actual deal documents, because we get involved in the drafting of that, and you can cover some of those issues in terms of reps and warranties in an asset purchase agreement. So those kinds of things come up. We can talk about that later, but. So at its very basic level, the diligence is sort of just making sure all the I's are dotted and the T's are crossed in terms of what the company says they own. And that's sort of basic diligence. And what we really do is, while we do that, and that's part of our process, what the value that I think we add is that we do what we call enhanced due diligence, which is covering the things that Jordan is talking about, where we're able to go and look at the target company, look at their patent portfolio, and not just see, okay, they have patents on this, but actually do a deep dive, look at the claims and the details of the patent, and make assessments and judgments as to whether or not this patent is worth the paper it's printed on. If they were to enforce this, would they be able to? Is it valuable? Because just because a patent gets issued by the patent office doesn't necessarily mean that it's going to be something that while it's presumptively valid, it's sometimes patents are invalidated every day of the week. So you want to get a sense of, okay, if this company, if a competitor came and tried to go into the market, could we use these patents to enforce against them and stop them from doing that? And so we do an assessment of the sort of the strength of the patents, and then we also match the patents to the actual commercial product to make sure it's covered. So there's a lot of different aspects as part of our enhanced due diligence process. That's not sort of the basic diligence, just confirming that everything is owned by the target company.
Mm-hmm. And as you guys are speaking, I'm thinking to myself, Jordan mentioned before, like battery technology. So I'm thinking, okay, so medical devices, technology companies, I'm just kind of describing target companies. But then even on the lower end of the scale, a donut shop, like a regular old Main Street business, a bakery, they've got a special formula, they've got a brand, they've got a trademark. So this is a huge area that I would imagine that buyers want to know all about their IP of the seller. So maybe you could kind of comment on the types of clients that you're typically working on in terms of the target client, who your buyer clients are, and how do they flex, like from the donut shop to the battery manufacturer? How do they flex, like the need for how much diligence is needed? How much work do we have to do to look at brands, copyrights, patents, and then, higher up on the scale?
Jordan, you want to take that?
Sure. Yeah. So typically, and this just goes to show sort of the range of services we provide. We've sort of handled diligences from, not the donut shop specifically, but companies that are the donut shop size,
right,
all the way up to sort of NASDAQ listed companies. And the way that we look at it is there's sort of a shifting scale, both in terms of sort of whether or not that transaction is being driven by considerations other than intellectual property, or if the intellectual property is the core feature of why this business transaction is going to happen. A lot of our diligence work is supporting private equity and alternative investment companies that are looking to put money in to sort of early stage medical device or early stage pharmaceutical companies. So in those instances, the intellectual property is the driving criteria for what's driving the sale. If this company says, look, we've just got FDA approval for this new drug, we think it's going to be a blockbuster, but we need a couple of $1 million to sort of get us over the hump. We take a really hard and sort of expansive look at the IP, because that's what's driving the deal. In terms of the donut shop, it might be that the intellectual property or what I meant to say was the technology for the donut shop, or a small bicycle manufacturer, or something of that size. The technology might not necessarily be patented or patentable. Even you can't just get patents on anything you think up. It has to meet a whole bunch of criteria at the patent office. So a lot of times with those smaller clients, there's a revenue model that works for everybody, and we're coming in to sort of make sure that, like you've all said, everybody owns what they say they own. The brands are owned by the company. There's no excess, an ex-partner or an ex-co-founder sort of lurking in the background who hasn't signed documents and is going to produce himself right at closing and make trouble for everyone. So those are the things we sort of look at the lower end. At the extreme end, at the billion-dollar transaction level, it can be all of the above. Sometimes, and we can sort of go into particular stories. We had an instance where we had to look at 1,000 patents because a car company was sort of being sold to others, and a lot of that technology was what was driving the deal. So you have to look at all of that, but you also have to look at what's the ongoing R&D. What's the ongoing employment situation? Are all these employees across the planet, like you all said, assigning their rights because they're inventors, or they are assigning their rights to the company? So that's sort of the level of diligence. It really gets key to how the transaction is being structured and what's most important for the client in their mind in terms of what's driving their desire to do the deal.
Interesting. So it's not just mitigating potential litigation risk down the road. It's really identifying the assets and making sure that what the seller is saying they have as an asset is truly theirs, and that it's backed up and protected so that there's no challenges to it in the future.
Right. Well, because one of the ways that you can, one of the things that you all had mentioned that we do in diligence is making sure that those patent assets actually cover the technology. Because one of the things that the buyer, if the buyer is coming in and saying, we're going to take over this company, we're going to pay you a premium for it, and we're going to then launch your new product, and this could be a pharmaceutical, it could be a new software app. If the new software application or new pharmaceutical or new battery is actually a market leader, but there was no patents for it, then there's competitors all over the place, and there's knockoffs coming in from overseas, and there's no ability to stop it. So the value of the transaction was somewhat premised on sort of having that market to themselves, at least for a few years. And if we look at the IP sort of situation and say, no, that's not the case. You can launch, you have no problems launching the product, but you'll have competitors within a year, and there's nothing you can do to stop them. That might change the value proposition of the transaction.
Right. Got it. Yuval, are you going to say something?
Yeah, I was just going to add that one of the things that is sort of central to our diligence process is we like to have a telephone conversation with the target company's outside IP counsel. And we have a series of we have a process where we essentially get documents first so we can review them, and then then we sort of go over those we have questions that we have, and then we go through those questions with the outside IP counsel, and the calls usually last anywhere from 45 minutes to an hour, maybe a little bit longer than that if it's a pretty detailed situation. But one of the things that we do during that call is we sort of, first of all, we usually start with general questions about, tell us about how the IP was created and the genesis of the company and all of that. But we get a pretty good sense during that call as to whether or not the company has their ducks in a row in terms of managing their IP assets, or whether there's issues. And we can pretty much, after that call, we know, okay, yeah, this company's got their ducks in a row. They know what they're doing. And sometimes, sometimes you'll find companies, you ask questions and they don't have answers for you that are satisfactory. And then, so that we can go then report to our client, yeah, we're a little bit concerned here, and there's some more diligence that we need to do because we didn't have the comfort level after speaking with IP counsel that they actually have done all the things that they're supposed to do to make sure that the intellectual property is properly, protected.
Got it. And during this conversation, we're talking about diligence when somebody is selling a company to another party, but it's something that Yuval, you and I have talked about, that it's not just IP is just not that conversation. It goes back to the company that is selling, that they've documented their processes. They've got an IP lawyer that they're working with. So maybe you guys can just talk for a couple of minutes about how does a company that may have good intellectual property go about understanding the need for a patent, a trademark, a copyright? Like, where does that start in the business owner's mind? Or where does it not start? And then they've got a problem that they've created something that's got value, and they're like, boy, we'd love to sell this, but we don't know what to do. Like, where does that conversation or mindset start for a business owner?
Well, I'll just start. I'll let Jordan chime in, but basically, our view of it is it really depends. Okay, if you're in the sometimes it depends really what your goal is when you start your business, right? If your end goal is that you might want to sell it at some point in the future, right? It is best to get your IP ducks in a row as early as possible, and the reason for that is in the context of, well, in the trademark context, right? If you develop a brand, but you don't file a trademark application for it, then your rights are going to be limited to your geographic area where you use that mark. And so, a year after you start using your mark, let's say in New York, someone starts opening the same name in California or in Kansas City, and then what happens is someone wants to buy your company and they want to expand across the country, and they can't do it because this other company or two companies are in different geographic areas. And so had you filed a trademark application in the beginning when you started your company, you would have had a presumptive nationwide rights, and that you would be able to stop those other companies. So filing a trademark application as early as possible, if you think you might sell in the future and there might be an opportunity for franchising or doing something where an acquirer wants to expand your business across the country, it's best to get your ducks in a row early on. Same thing with on the patent side, is that there's a clock ticking from on the patent side. You have to file a patent within a certain time period from when you first sell the product, or even when you make it publicly known, and it's a 1 year window. And if you start selling a product and then 2 years down the road you say, you know what, I'm interested in filing a patent on this, we're getting some traction here, you're out of luck because you waited too long. So just as a general rule, I think, look, I understand that when you're starting in the business, there are a lot of expenses, and the last thing you want to do is spend money on lawyers. But it is actually a good investment to consult with an IP lawyer as early as possible, because there are certain rights that you may be waiving by not doing things earlier rather than later. And
Jordan, did you have anything to add that?
Yeah, other than to say that, the time when you start thinking about, and I'm speaking as a technologist, as a person who deals with technology companies and not just exclusively, brands. If you're a smaller company, if you're sort of thinking about starting a company and your aim is to solve some problem, to build that better mousetrap, once you figured out what that better mousetrap looks like, that's the time to start thinking in terms of patents. Once you've sort of made the invention, Yuval sort of brings up the time limit for filing patents, and it's kind of a critical issue, because a lot of times people will come to us with their better mousetrap or their improved battery or their other device or process, and they disclosed it or shown it on social media, for a year, or they sort of live stream them working on it, and we're going to build this new thing, come into our workshop, and there's a series of YouTube videos in their workshop over the past year where they document all of it. All of those are great content. I like them as much as the next person, but it always breaks my heart a little bit when someone is just giving away the store on TikTok or something. Before you do those things, you talk to a patent attorney, see if it's something that might have value for you, and then you can sort of spin that. But you disclose things the whole world is watching, and you will be surprised how quickly a competitive or even identical product to the product you spent a lot of time in your garage thinking up is on the shelves someplace before you can. And so that's really the time to start thinking about things. Is you have a problem you want to solve and you think you can solve it. That's when you should sort of pick up the phone and spend at least a little bit of time, if not capital, seeing what your options are.
Yeah, because like you mentioned earlier at the very beginning of the conversation, IP is an asset that's not like a piece of real estate that you can see, you can touch, you can have a title to. You may create this IP that is nothing other than an idea until it's really on the market, and then it may be too late. I think that's a great example of, good conversation around that 1 year window. I would have had no idea about that. And there's so many founders or potential founders that we hear and talk about and meet with. I'm sure that you guys do, I do as well, that are in the technology field. They've got an exciting idea. They think they can fix a problem, like you said, Jordan, and they're going to come out with either an app, a piece of technology, a piece of hardware, a device, a medical device, or a drug, or whatever it may be, a therapeutic. And they get so far down the road, they've got funding. And I'm sure that when a venture capital firm is putting money into something like this, they're forcing them into the IP conversation before $1 crosses the table. But it's so interesting because there's so much activity that we're seeing. And then to kind of couple that with social media, like you said, they're so anxious to share with the world. And then it's like, one huge oops.
Yeah, it's always heartbreaking because people will come into our office, they'll sit down, they'll show us something, and I'll say, how long have you been doing this? And they'll say 2 years. And I say, well, who else knows about it? And they say, oh, well, I'll send you the link to my Instagram. And I go back and there's dates, and you just keep scrolling until you hit a year, and it keeps going. And you say, okay, yeah. Now we have to think through some other possibilities here because some doors are closed to you. So it's that excitement, that this sort of desire to both raise capital, and sort of show that you're, in the mix and you're sort of contributing, that gets people into trouble sometimes. So it's sort of a little bit of, close to the vestness is always a way to go forward. There's always time later to sort of make that big social media push.
Yeah. And do you guys get called in by venture capital funds or accelerators that are putting money into potential new devices or inventions or technologies to vet out IP risk? Yeah.
It happens. It's sort of a core part of our diligence practice, is sort of working with, family offices, VC funds, private equity, alternative investments, and that sort of runs up and down sort of the deal size chain. But yeah, one of the things that we get asked a lot is, we're interested, and this is the client, we're interested in this startup. Is there behind it? Do they say they have patents? Do they have patents, or do they have patent applications, right? Because a patent application is sort of the desire to have a patent, but unless you get it doesn't function as the sort of exclusive market clearer that an actual patent does. And so sometimes people, well-meaning and interested in sort of getting the deal done, will sort of say, well, we've got lots of patents. And what they mean is we filed for a lot of patents. And then you sort of have to work through the risk profile. How likely are these patents to be granted? If you go to the patent office with, you invented the question mark as your patent, you're not likely to get it. And so we get asked to sort of look at things in process and, game out whether or not we think it's likely to happen. And Yuval can speak to this as well. So sometimes what ends up happening is that the VC firm is interested because they're interested in the founders or they're interested in the concept, but they're less than thrilled with the IP position. And so the VC firm might then ask us to step in as IP counsel for the target company and clean up the IP, file some new patent applications that have a better chance of getting through the finish line, and being more targeted towards what the actual go-to-market strategy is. Sometimes you get very, very nice, very interested engineers who will wander off on a tangent and say, "Oh, well, we've done this and that." And sometimes the VC guys say, the budget is to capture the core commercial product and not these other things. And sometimes we get brought in to give focus to that.
Yeah, I'll just add to that. Just as this is a case study that I kind of like talking about, which is that we had a client that basically was a family-owned business. They were in a technology field of semiconductor cleaning of semiconductor wafers, and they basically didn't believe in patents. They did everything. They kept everything as trade secrets, and a larger company looked at them and said, you guys are a technology company. How do you not have patents? And they passed on an acquisition opportunity. And what happened was a private equity company purchased the company, and they basically came to us and said, look, we want you to develop a patent portfolio for this company because we want to sell this company, and they weren't able to sell because they didn't have any patent assets. So essentially what they did was they essentially said, I want you to meet with all of the engineers at the company, and I want you to file as many patents as you possibly can. And we wound up doing that. We wound up developing a really nice patent portfolio. And then the same company came back to look about acquiring the company, and they wound up acquiring the company because now they had patent assets, and they paid $150 million to buy the company. So wow. It's always a good example of, you asked, do we ever get hired to do that? Yes, the answer is yes, and we've done that, and we've done it successfully because that was a good outcome for this company. So that happens a lot, and as Jordan said, the other thing that happens is when we're doing diligence, sometimes we'll find holes, and we'll say we'll put together. We typically, when we finish a diligence project, we put together like a memo to the either the acquirer or the investor, and we sort of outline risk factors that we see, and sometimes what we'll say is these patent applications that they're filed, they could be better, and they could capture things, and these are the things that we would recommend doing. And then what will happen is after the deal closes, since now our client is a significant investor in the company, they will recommend that the company hire us to actually implement the recommendations that we made.
So that brings up two questions I have, and the first one is Jordan mentioned a tech firm may say, oh, well, we've got patents, but really they have patent applications. So the first question is what's the general length of time it takes from filing an application to actually getting a patent?
It can vary, and I'll give you the classic lawyer answer, right? Which is sure. It depends.
But that was my answer to everything.
Right. And but there are levels, and you're dealing with a government agency, so obviously it's not a speedy process. Typically, the patent office takes about 2.5 to 3 years between when you file your patent application to when you get a patent examiner at the patent office who picks it up and either sort of says yes or no. And if they say no, it's not the end of the world. The patent prosecution process is long and actually quite boring for people who aren't like me and make it their sort of life's work. But it can be a number of years from when you file an application. There are ways to take some shortcuts. Again, government agency, you sort of pay more money and things will go through faster, but it won't guarantee you the good outcome. It'll just, it can guarantee you a no faster. And sometimes that's all a company needs to know, is whether or not this was something that we were going to get a patent on or we weren't ever going to get a patent on. But there's no sort of way to sort of fast track patent applications in a manner that sort of assures they're going to turn into issued patents. That is the interplay between patent attorney and the patent examiner. And that can go on as long as the client is sort of willing to fight for it, because the patent office, it shouldn't be understated, is not in the business of giving patents to anything. They sort of have a mandate. The mandate is in the Constitution, right? It's to sort of promote the useful arts and sciences. So what they're looking for is sort of new, non-obvious inventions. And so they don't like things that seem to them like business methods, things that could be done by people, things that could be done by an accountant, that you've just sort of turned into software, and things that aren't, made by people. So, in certain respects, sort of naturally occurring plants and, minerals and things like that. So you sort of have to know what you're getting yourself into in terms of what your technology actually is. If you're a chemical refinery, you're not going to get patents on the refined compound. You're not going to get a patent on gasoline, but you could get a patent on the process of refining it that's more efficient or something like that. Mm-hmm. And that's what you sort of go into the patent office with. And a lot of times what confuses investors or confuses acquirers is that sort of the different classes of patents, because you can both get patents on things, inventions, compounds, but you can also get patents on processes. And so it's slightly different. It's one thing to say, well, I'm going to corner the market on this new type of fuel additive. And it's another thing to say, well, I'm going to corner the market on a way of making a new type of fuel additive. Ideally, you would have patents on both, but sometimes that's just not possible. Either you disclosed it or you didn't do something else. But to bring it back to your original question, that all of those things sort of increase the length of time. So typically, we find it's there shouldn't be an expectation if you filed a patent application last week from an investor standpoint that you would see an issued patent somewhere before 2025.
Got it. And the second half of the question is for Yuval, and that is that after a patent is filed, did you kind of infer that you're going to go back to the investor and say, yeah, they've got a patent, but it's not really great. You can go back and reform or perfect a patent application or broaden it. Is that what you were inferring before?
Yeah. So the answer is yes, under certain circumstances. So
it's going to depend.
It's going to depend, exactly. So there are and I'm a little bit out over my skis here, but just in terms of the patent prosecution, but and Jordan, so chime in if I get anything wrong here, but if a patent application is not yet issued, there's an opportunity to file different kinds of applications off of that first application. You need to have, it needs to be basically related. It's really for improvements, right? So you can really, so you basically take the original application and you can file what's called a continuation application. And then that will eventually become a separate patent that's related to the first. They're sort of part of the same family of patents. How did I do, Jordan? Is that good?
Yeah. You got it. The reason why you're allowed to do that is that patents currently have a term of 20 years from when you file them. So when you sort of make these child patent applications, you can't add anything new to the application. So the application needed to be written in a way that was pretty expansive. But again, because this is a government agency, what can happen is you can write a big patent application. And like I said, a process of making a gasoline additive and the gasoline additive itself. And you could go to the patent office and ask for both. And the patent office will say, well, you only paid for one invention, so you only get one. But you're allowed to then make one of these branching child applications. So if you took the additive in the first case, in that child case, you might take the process. You can't sort of add in more information than you had when you originally filed, but you can go back and mine your original application for all the inventions that might be sort of buried therein.
Got it. So I've got a third question for you, and this is a little humorous, so bear with me. Jordan, you made the comment that someone would try to patent that they invented the question mark. And I've got to ask, is that an Austin Powers Dr. Evil reference?
Yes, very much so.
He would make outrageous claims like he invented the question mark.
I find it's one that most inventors that I meet with today, they get that reference. As I get older, and maybe the startup founders stay younger, I'll have to find something something that works well. But
you'll have to find that clip on YouTube and just send it to them so they appreciate it.
Exactly.
Well, guys, it's been a good conversation. Is there anything we left out, anything that you'd like to cover with regard to IP diligence before we kind of close up?
I mean, the only thing I'll say is that just to the extent that it wasn't clear from the conversation is, we're only doing one small piece of the diligence. We're typically working as co-counsel with corporate counsel that handles all of the other aspects of the diligence that doesn't touch on IP, and there's a lot of other kinds of diligence involved in a particular transaction. We typically work with large general practice law firms that handle sort of the corporate, we call the corporate diligence, and then we're just focused on the IP aspects. The one thing I would add is, in addition to sort of looking at the target company, another thing that we will do as part of our diligence process is we will weigh in on the IP aspects of the actual deal documents. So because we've done the deep dive on the diligence, we want to make sure that the agreements reflect the risks that were disclosed during our diligence process. We will share our conclusions with the client. Typically corporate counsel will know what we found as part of our IP diligence review, but a lot of the times we will get directly involved in making comments. They usually will corporate counsel will run the IP sections of the deal documents by us for our comments, and there have been times when we've actually negotiated those IP clauses directly with the other side. So that's just another aspect of it that I thought was worth adding.
Yeah, good point. And I think that, as a broad statement, diligence is, depending on the size of the deal, diligence becomes a bit of a, five-headed monster that can get out of control. So there is usually one central corporate attorney that's kind of, or a deal team member that's kind of coordinating all of that. And there are so many aspects. We've gotten involved in insurance and risk diligence on private equity transactions. So yeah, there's a lot of players in that. Jordan, anything else to add?
No, other than, we appreciate your time and letting us talk our book here.
Yeah, it was a good conversation. I appreciate you guys coming on. Before we roll,
thank you, Gordon.
You're welcome. Do you if Yuval, and I'll ask you both separately, Yuval, if somebody wanted to reach out and get in touch with you, how's the best way to do that?
Okay, so the best way to reach us is through our website, which is www.leesonellis.com, LEASONELLIS.com.
Okay.
Also, that's probably the best thing, because we all have profiles and you can download our V cards and get access to our information that way. We're both also active on LinkedIn, so if you Google our names, you'll find us on LinkedIn as well.
Great.
Except there is a minor league baseball player whose name is also Jordan Garner, so you're going to have to go to if you Google me.
There actually, believe it or not, there actually are a few other Yuval Marcuses out there as well, but none of them, as far as I know, are IP lawyers besides me.
Good to know. And what I'll do is I'll put all that information in the show notes and the description box on YouTube. So, and I often say this, if somebody's driving in the car or they're on the treadmill, they don't have a pen and paper handy, they can go back to the show notes and get that information. And before we close, my name is Gordon Coyle. If you have an interesting story that you'd like to tell on this podcast, give me a call or drop me an email. I'll put my information in the show notes as well. And until we see each other again, have a good day.
That's it for this week's episode of the New York Business Leaders Podcast. Be sure to subscribe so you don't miss next week's episode. In the meantime, find more interviews and resources at nybusinessleaders.com.